We're just checking. Yep, the audio seems to be working. Great. Welcome everyone. For those of you who don't know me and who weren't here last week, my name's Beck. I'm the comps director, so I'm the person who's been emailing all of you far too regularly. And Igor, who is the novice Moot coordinator, is down the front again. Hopefully I won't bore you all too much in this seminar. You'll be pleased to know that in addition to the boring PowerPoint, I do have a piece of paper here with anecdotes written down on it, so hopefully I will be able to break up the mooting preparation monotony. And that's it. It's not that boring, it's just there's a lot of information that I need to give to you. Do feel free to interrupt me at any point to ask questions if anything is unclear, and at the end I'll be pointing you in the direction of a few more useful resources. So that's basically what we will be going through. Has everyone, just to make sure, has everyone gotten the draw in the problem for their moot? Yes, no one is lost? Okay, fantastic. It's very good to know. So the first step, as I'm sure you're all aware, is analysing the problem. And I know that the whose side are you on question seems like an obvious one, but you would be surprised that occasionally people do stuff that one up, and that's not a good one to get there and realise you've made a mistake about. So do double check the draw and make sure that you have it clear whether or not you're appellant or respondent. It's also good to note whether you were originally the plaintiff or the defendant, because when you're making submissions you may want to refer to yourself as being the plaintiff or the defendant. So you might be both the appellant and the defendant in the original proceedings. So just make sure you get that clear in your mind. The second thing you can get from the problem is the jurisdiction. So that might tell you something about the problem. It won't necessarily, it might be totally irrelevant to the problem. But if something is in the High Court, there's going to be a lot more scope to run policy arguments or to run arguments about the law taking a particular course in a controversial area. So do just make a note of the jurisdiction because it might come and help you. The next question is there anything that stands out in the facts? Obviously you won't have done all of your legal research yet, so it might be hard to know what is and isn't relevant. But when you first read the problem, if particular things strike you as being important, and I would say that most of the time, if a particular fact has been included and it seems strange that they've included that information, it probably means it's going to be relevant later on. Just note it down and also note if there are any important concessions in the agreed facts. I would say now, from the anecdote sheet, do make sure that you get a really thorough grasp of the facts, because there is nothing more embarrassing than getting up and mooting and having the judge correct you on something in the agreed facts. And unfortunately it can be really easy to do. You get caught up in doing the legal research, you do all your submissions, everything's great, until you're standing up mooting and you realise that you've made a fundamental error about the agreed facts, and the judge has read the agreed facts and has just pulled you up on the error. And there's very little that you can do to finesse your way out of that one, other than admitting you've made a mistake. So do make sure that you're across the agreed facts, and particularly across anything that you're going to use in your submissions. If you're going to make a big factual point, make sure that the factual basis of that submission is actually correct in the problem. The next step is, in all of the problems we're giving you, the legal issues are set out really clearly in the grounds of appeal. Don't make up new grounds of appeal or argue different grounds of appeal or anything like that. You are restricted to what's there, and you also can't make procedural submissions, which is probably only going to be a temptation for those in final year who have done things like DRE, but don't make procedural submissions. Just stick to the grounds of appeal, and that will keep everyone and the judges happy. You might also notice that legal issues have been conceded. So if a legal issue has been conceded, you don't need to talk about it or waste time dealing with it. So an example is you might have a contracts moot problem, and there might be no real dispute about whether or not there was consideration, for example. If that's the case, you don't need to go about establishing that there was consideration and a binding contract, etc., etc. Just focus your submissions on the grounds of appeal and the issues that are in dispute, because you only have half an hour between the two of you to get through all your material. And one of the strange things about mooting is 15 minutes sounds like a long time to be making submissions, but once you're on your feet, it will feel like 2 minutes, particularly once you start getting questions from the bench, you start interacting with the judge, and you'll suddenly find that what you thought was heaps of time is no time at all. So do bear in mind that you want to be as succinct as possible and get through as much as you can as quickly as possible. The next thing to bear in mind, and the place you probably want to start your research, is there any legislation and what provisions are relevant? Because that will be step one in your exploration of the legal problems. What are the relevant provisions, how old they are, and are there any similar provisions are important questions, because often moot problems will be about relatively new legislation, because when they're writing problems, sometimes it's good to look at provisions that have just come in and get mooters to examine the way that might change the law or how things will stay the same and so on and so forth. So just bear that in mind. Both of the first round problems, you've been given case lists, and it says on the case list, but I will reiterate now, you're not bound by them in any way. So you don't have to cite those cases. You can cite additional cases. You can't cite any additional legislation. So no legislation that hasn't been given to you, but you can go crazy with the cases. They're just a springboard for further research. And then final question, how do you want to divide the material between the two of you? So I know a lot of people are actually in teams with a friend. For those of you who aren't, if you have any problems contacting your teammate, please let me know and I will email the two of you and put your email addresses together so you can get in touch. In terms of dividing the material, really it's just what interests you, or you can do it in some arbitrary numbered way. It doesn't really matter. The moot problems are designed so all of the points will be A, arguable, and B, of about the same quantity of material in them. Sometimes that varies a little bit, but most of the time they'll be about equivalent. If you find that there's one point which you think there's just is no material on this, that might be justification for splitting your time 20 minutes, 10 minutes, or 10, 20, one way or the other, to make sure that the big issues get dealt with at length. On that, you wouldn't be penalised because you speak for a shorter period of time than your co-counsel, basically. So don't worry if you do decide to go with 10 minutes. It's true you don't have as long to engage with the judge, so that can affect your score in a way. But if you make really excellent submissions for 10 minutes, you'll do just as well as if you've done that for 15 minutes. So general research, and just actually to get an idea, who in here is in their first year? Okay, great. So some of the general research stuff, and I do apologise to those of you who are in your later years, will be stuff that you already know. So I am very sorry, and it will be boring and repetitive for about 5 minutes. Or you might discover a random legal resource you didn't know existed. But the first step should really be to consult a general source. All of the textbooks for various subjects are on Law Reserve, so if you want to go down to the law library, you can get them for 3 hours and have a quick flick through. Because for you guys, most of you will have done the areas of law the problem is on this round at least. This won't be as much of an issue, but if you find later on you get a problem on an area of law you just haven't studied, then it's always good to go and have a look at the textbook just to get a feel for the area. Another great resource is Holsbury's Laws of Australia, which some of you probably have found on LexisNexis. It's an enormous encyclopedia that's updated by a variety of academics and professionals, which basically covers everything you could possibly want to know about the law in Australia. It is searchable by keyword as well, so it's very easy to navigate. And I would recommend that if a textbook doesn't help you, you should consult Holsbury's. If a textbook does help you, you should probably still consult Holsbury's because it's fantastic. It's often more up to date than textbooks, and it actually tells you when it was last updated, so you can check and see when it was last added to. The encyclopedia on Thompson's, for those of you who have discovered it, is also fantastic and similarly searchable by keyword or by category. Ford's Principles of Corporations Law is online as well, and that's a great corporate law textbook. As I say there, even if you've been given a case list, you'll want to read the cases against the backdrop of the area of law. So I'd suggest you go to a general source first, because it will be difficult to plough through all the cases if you don't really understand what's going on in the background. If there's legislation, you can run a LexisNexis search on the section of the legislation, and that will pull up all the cases that have considered that particular section. And that's another great tool to start with at the beginning, because you can get an idea of how many cases, whether they're important. That said, depending on the provision, there are some provisions you will run and get hundreds and hundreds of hits. In that case, it's probably best to just go back to a general source and look at the key cases and what's relevant. Other sections you'll run and find that there are 4 hits, and then you probably do want to pull up those cases and have a look. I don't think I have a humorous general research anecdote, I'm afraid. No, I don't think there's much that can be said that's funny about general research, so I'll try and make up for that later on. The next step is to, by this point in time, once you've done your general research, you should have more of an idea of what the grounds of appeal are getting at and where the real legal issues are. Because I understand often initially you'll look at the ground of appeal and you'll think, I don't really know where the real controversy is or what I need to be arguing to either agree or disagree with that proposition. By the time you get to the end of your general research, you should have a good idea of that, and also a good idea about the general area of law. Because while your moot is restricted to the grounds of appeal, it's good to have a little bit of background knowledge, because sometimes your judges might ask you a question about the way in which your moot problem interacts with other elements of that area of law, and it's always good to be able to answer those questions. This is again a piece of information that is probably not going to be useful to those of you who are not in first year, but may be useful to those of you in first year. Thompson's has a fantastic full text capacity for Commonwealth law reports and many, many other law reports. So I would always go to Thompson's for full text versions of cases, which you will be looking for, I hope. LexisNexis does have a few random report series that Legal Online doesn't have. It also has High Court cases, but with their ALR citations. Now, if possible, you should try and use the CLR citations, because for those of you who are doing PPL, I believe you're doing all of the citation stuff at the moment. If you can cite an authorised report series, you should, and the Commonwealth law reports are an authorised report series. So again, it's a really fine detail thing, but the more professional you can make your submissions, the better. So if you can use the CLRs, etc., it will just make your submissions look more professional. Westlaw. For those of you fortunate enough never to have used Westlaw, well, actually that's not true. Westlaw is a great resource once you've actually learnt to use it effectively. The problem is I personally, this is only opinion, I just realised I was being recorded. I personally find the search interface quite difficult with Westlaw and sometimes very temperamental. So Westlaw, I think, is best when you are searching for a particular foreign case. So you will have to go to Westlaw if you're looking for something from the United Kingdom or anywhere else. If anyone works out how to effectively use Westlaw for general research, then they can email me and tell me, because it's always defeated me. But it is a fantastic resource for foreign jurisdictions, and I hear that some people also use it as a very effective general research tool. It's just not one that I've ever gotten along with very well. The final general piece of mooting research information is Legal Online's First Point Citation Database service, and also Lexis, which has a similar thing. If you look up a case, and there are pictures of this on the discussion board, which I will tell you about later, if you look up a case, it will give you not only the litigation, the history of the litigation, but it will also give you a list of all the cases that have applied that case, followed it, explained it, distinguished it, and so on and so forth. So as I'm sure you can appreciate, that gives you a wealth of resources on a particular area of law, and it's a very good way to look at where a doctrine has gone. It also conveniently tells you if that case has been overruled, and that's an important thing to check, because another embarrassing mooting thing is when your submissions have been written on the basis of a case that was overruled and your judge knows that and asks you about it, because that's another one that it's very hard to recover from if that happens to you in the middle of a moot. As with most mooting errors, it doesn't really matter, it's all water under the bridge in the end, but if you can avoid it happening, I would recommend you try to avoid it happening. And it's quite easy just to check to make sure that your case has not been overruled. Research troubleshooting. These were the kind of two of the common research problems I have found mooters have had. One is new legislative provisions. Questions to ask, are there old provisions which are pretty much the same? Are there any state or other acts which are similar? Are there any UK statutes with similar language? The answer to one of those questions will ordinarily be yes. Sometimes it may be no. It might just be that these provisions are new and unprecedented and there's very little authority about them, in which case you just make your submissions as best you can and try and make logical arguments. And that's probably something that it's worth to stop and just talk about briefly now. We've talked about research generally, is that as you're going through all of this and reading all of this material and structuring your grounds of appeal and thinking about your submissions, remember that in the end, logical arguments almost always carry the day. Because most of the time, your judges, while they will have read your submissions and the bench notes, if we've given them bench notes, and a little bit about the law, they're probably not specialists in whatever area you're mooting about. So nothing will be more compelling than an eloquently put logical argument supported by some authority. So do remember that when you're making your submissions, and think about making sure that all your submissions fit together as a logical whole and that you can explain them really clearly and quite simply in some way when you're standing up to give your submissions. The other thing to bear in mind about that is occasionally you will get a judge who perhaps has actually misread the agreed facts or similar. Do feel free to gently correct them as respectfully as you possibly can. So there are two ways to approach the judge who has not read the agreed facts, and one of them is to say, well, Your Honour, you're wrong, the agreed facts say X, and I wouldn't recommend that. The other way is to say, well, Your Honour, with respect, we do note that in paragraph 8 of the agreed facts, this is referred to, and then your judge will probably be embarrassed and glad that you weren't aggressive, and you will get kudos for that. So another good reason to make sure you know the agreed facts well. That is another piece of advice I have written on my anecdotes sheet. And I have written here, don't be sassy with the judges. And that is a very good piece of general mooting advice, because probably one of the worst moments I ever bore witness to in a moot was when someone decided they would get sarcastic with one of the judges and they thought that they would be a little bit snarky. It didn't go down at all well. So please don't do it, particularly if you're appearing before an actual judge or a silk, because they will not appreciate it if you decide that you're going to be sarcastic or disrespectful. With mooting, the more respectful you are, the better as a general rule. That doesn't mean you can't disagree with your judge, and if you can disagree and argue back in a respectful way, the judge will probably like that because they want to see you're confident in your legal ideas. But being rude to the judge is a very big mooting no-no. At best, you will score very poorly. At worst, you will get shut down very brutally by your judge. So don't do that, okay? And it's easy to avoid doing that. The other research troubleshooting issue is where there's very little Australian authority. And that doesn't happen that often, but if that's the case, your first port of call should be the UK. And then after that, other jurisdictions, New Zealand, Canada, the US. Bear in mind that if you're using cases from foreign jurisdictions, you'll need to make sure you explain really clearly why that doctrine should be incorporated into Australian law. So make sure you do that rather than just saying, well, in the UK, X is the case, because in the end, that's only step one. Step two is saying, and it should be the case in Australia because. So once you've done all of your general research and you've looked at all of your cases, you should have a good body of research. To give you an idea of how many cases would ordinarily be cited in a moot, I would say between 10 and 15 would be the norm for your average moot. Sometimes if a moot problem is really technical, it could be up to 20. In general though, I would say shorter lists of authorities are better for a couple of reasons. You should of course have cases in there that support all your legal propositions, but every case you list in your list of authorities you should know. You don't need to know the judgment by heart or anything like that, but you need to know what the case is about and you need to know how it fits in with your submissions. It's quite unusual for a judge to ask you a question as blatant as what are the facts of that case, although it does happen occasionally and quite a few people have come unstuck as a consequence of that question. But there will often be times when you'll need to know a little bit about the case in order to answer a question about it effectively. So do make sure, some people make up case tables, which are actually quite useful if you have the time and inclination, where you have the case and the legal principle and a little factual summary, so that if you do forget while you're standing up there, you can have your table in front of you and you can refer to it. So that can be quite useful. So I say here, you should support each proposition of law with at least one authority. One is often best. You don't need to put 5 authorities for a proposition of law, particularly if it's uncontroversial. So cite the most recent articulation of the law in the High Court if you can. If not, go for one of the Superior Courts. New South Wales Court of Appeal is always good. You don't need to cite just enormous numbers of cases for all of your propositions because, one, it makes you look like maybe you haven't read all of these cases, you've just pulled them from a textbook and put them in your submissions. And B, it means that you risk the judge deciding that they want to know why you've cited that case there because they know all about that case and they're really curious about how it fits into your legal arguments. And in fact, you don't know anything about that case, and that's not a pleasant situation to be in. So, yeah, as I say there, saturating your submissions with authority won't convince the judge that you know what's going on. What will convince them that you know what's going on will be you making forceful, clear submissions supported by 1 or 2 key cases. When you're at the drafting stage, also think about any arguments you want to make in the alternative. So with arguments in the alternative, you may find yourself in a situation where there are 2 compelling arguments you want to run, but they're inconsistent. If that's the case, you need to put the second one in the alternative. Always put the strongest argument first, is a general rule of thumb, because that way, if the judge is convinced of the stronger point, then you may not need to make the submission in the alternative. Another good way to use submissions in the alternative, both in your submissions and as a rebuttal tool, is to use them to basically say, even if we accept a proposition made by the other side, you should still win. So that's another way that you can do it, by saying, even if you're not satisfied that this is the case, we say that we should still succeed because of Y. Finally, are policy arguments. So policy arguments should be approached with caution in mooting as a general rule, because it's not like debating or some other forms of public speaking where you can sort of fluff and wave your hands and speak eloquently about a particular area and be quite compelling. Mooting is really all about the application of the law. So policy arguments have a couple of key utilities, and beyond that I would try and steer clear of them. If you find your submissions are turning into one long policy argument about why the law should take a particular direction, then you probably want to rethink the direction of your submissions. But policy arguments are good in 2 cases. Firstly, where there is strong competing authority. So you might get a moot problem where there are 2 lines of authority that are conflicting and you're trying to persuade the court to pick one, particularly if you're mooting in the High Court. In that case, policy arguments are good because they allow you to say you should take this approach because there are good policy reasons for it, and that's fine. The second place where policy arguments might be necessary is if there is no authority on a particular point, and either you're trying to persuade the court to follow foreign authority or you're trying to persuade the court to follow some sort of different argument that you have concocted from the language of the statute, etc. That's where policy arguments are good. Otherwise, try and stick to the law. Is everything making sense so far also? Yes, good, useful, good. A few sort of strong nods, that's good to know. I prepared this presentation, and as I was going through I thought, I hope I don't bore everyone to death with it. But I also thought a lot of these things are things I didn't know when I started mooting and wish that I did. So I hope that it will be of utility to you when you prepare your submissions. And good submissions, people tend to mooters tend to think that written submissions aren't that important. And it's true that your written submissions aren't worth an enormous portion of your mark. But your written submissions are also the first interaction with you that your judges have. They get your written submissions on Monday afternoon or Tuesday afternoon and they read through them. And so your first impression on your judge is through your written submissions. And if you have fantastic written submissions that are professional and sensible and logical, you will immediately impress your judges. If you have submissions which are incoherent or poorly worded or full of grammatical errors, etc., then that's the first impression your judge gets. And I've had judges say after moots, I was really surprised at how good the appellant team was because their written submissions were rubbish, etc. I expected them to be terrible. So your written submissions do formulate a first impression of you, and it's good to make a good first impression. So this is basically, okay, the anatomy of a submission is a little bit postmodern, but forgive me. This is basically how a submission is broken down. So you've got your broad proposition of law at the top, then you've got any secondary legal propositions, then you've got the application of legal propositions to facts. So the reason I have broken this down like that is because a mistake that a lot of mooters make at the beginning is citing cases for propositions of fact. So basically you want to cite authority for your propositions of law, but not for your application of the law to particular facts. So, for example, say this is your submission here. You set out the broad legal principle, you set out a secondary point, and then you talk about how it applies to your particular facts. That's how it should be done. This is less ideal. So the problem with this is basically you're citing a case for your proposition that the age of 70 and the dementia places someone at a special disadvantage. Now, unless that case is actually about someone aged 70 who had dementia being at a special disadvantage, it's not legal authority for that proposition. So the way you should do it is always general principle of law, secondary legal principles, application to the facts. And that will assist your judges, because certainly it's something like my first couple of sets of submissions, I know that I made that mistake, and it was something that I was eventually talked to by a judge about in terms of make sure you don't do it, because it does send off alarm bells for judges, because they're like, why is there a case for this proposition of fact, etc. Okay, things to avoid. And there are some, you'll be pleased to know, some anecdotes. One thing I would say, which I think I left off here, is try to avoid heinous grammatical or spelling errors, and try to avoid, for example, I once got a set of submissions from a team, and one of the sentences just stopped halfway through the sentence. Their submission went on and then it just terminated. And it's not really a good look if your submissions stop mid-sentence with no indication of where you were going, etc. The other thing is try to make sure that they're grammatically correct and that the spelling is good and so on, in the same way you would before you hand up a piece of work, and that your citations are good and consistent. So things to avoid, we've talked about authority. Placing reliance on a dissenting judgment is a good one, because occasionally, and I'm sure everyone has had the experience of reading a case and thinking, wow, this is really compelling stuff, this all makes sense to me, and then realising that they're reading a dissenting judgment. Don't base your submissions on a dissenting judgment, because you might get away with it. You never know, the judge might not have read the case, the judge might not notice, etc. But if the judge does notice, you're going to be in trouble if you've based all of your submissions on one of Justice Kirby's dissents, etc. Secondly, failing to persuade the court not to follow persuasive authority. So this is something that I know happened a lot in the first year moot last year. So if you have, say you're arguing a particular proposition and you're in the Supreme Court of South Australia, and there's a case from the Supreme Court of Western Australia that makes a particular proposition, a lot of people will just say, well, that case is not binding, it's persuasive, and then move on, which is not enough. If you want the court not to follow persuasive authority, you need to explain why. And there's also a doctrine in Australia, which I think is referred to in the Mooting handbook, that intermediate courts basically should follow the legal doctrines laid out by other intermediate courts unless they think the decision is clearly wrong. So you can't just say, well, that happened in Western Australia, so too bad, it's not binding. It's still persuasive. So persuade the court not to follow it or persuade them to follow it, either way. Another couple of things, and your judges will notice if you do that and will say, but why shouldn't I follow the decision of the Western Australian Supreme Court, etc. So come up with some compelling reasons because you'll be asked. The other thing some people do is sort of cherry pick. It's like the patchwork approach to mooting, where you go to a lot of cases and you sort of pull out quotes from judgments and put them all together into submissions and then deliver them without ever thinking about the overarching principles or implications of the submissions that you're making. And you should avoid doing that because in order to answer questions effectively, particularly, you need a good idea of your broad submissions, where they're going, how everything fits together, and you don't get that by pulling out a whole stack of quotes from judgments and turning them into submissions. The factual errors thing we have already talked about. Again, using authority that's been overruled or expressed as confined to its facts. The final one is spending huge amounts of time reciting the facts of all of the cases you cite, which occasionally people do, and it's great to demonstrate that you really understand the facts of the cases that you're talking about. At the same time, if the moot is about, I don't know, contracts in a family context, the court probably doesn't need your very comprehensive and excellent explanation of how in a particular case two building companies entered into various contracts and so on and so forth. So to the extent you use the facts of cases, make sure you're only using them where they're actually relevant to your submissions and not just to explain them superfluously, because you will waste time and you don't have time. In mooting, you will never have enough time. So half of the art of mooting is just learning how to fit it all into your 15 minutes. That is just a pre-submission checklist, putting everything in to make sure that it's all good. Oh, the other thing to do is make sure your materials refer to the correct parties. And this is an embarrassing story that I actually have to admit I have been guilty of. Because after a while, you'll find you probably have a submission template and it will have the headings and everything on it. And every moot, you'll just adjust the template. And on one particularly humiliating occasion, my team had adjusted the template, but not quite thoroughly enough. So where it should have had the learned trial judge did not err, it said the learned trial judge erred. And not only was it an embarrassing omission, it was also something that one of the judges noticed and called one of us up on and said, wait a sec, in like ground of appeal 3, you say did not err. Does that mean you're conceding and agreeing with your opposition? And we were forced to say, no, Your Honour, that's just a typographical error. So it's not a fatal error, but it is embarrassing. So do make sure you've changed it, like get appellant, respondent, did not err, did err, and so on and so forth, correct in everything. That's the other thing I wanted to say generally, is if you talk to people who've done a lot of mooting, I guarantee they will have at least 2 or 3 humiliating stories. They might not tell you about the humiliating stories, but they definitely have them. And the reason that I've told you some things to avoid is also to illustrate that everyone has terrible moots. Everyone makes the odd appalling submission, but that doesn't mean you're not a good mooter, and it doesn't mean you should give up mooting immediately. It just means you should learn from it, get over it, and move on to the next moot. Because I think most of us have submissions we would like to take back, or times when under heavy questioning we said something that we would ordinarily never have said and that we knew didn't make sense. But that's what happens. And it's like advocacy in the real world. You can't always anticipate what questions you're going to get, and so on and so forth. So don't worry if you do make a mistake, particularly in your first moot. I don't know many people who look back incredibly fondly on their first ever moot, but I guarantee that things go uphill from your first moot. And if you do love your first moot, then you're going to be a great mooter and you're going to enjoy it. But if you don't have an amazing time, then remember it gets much easier. Final words of wisdom about practicing submissions. Do practice them, don't script them. And this is something that I'm sure most people will probably ignore, but I will say it nonetheless. Scripting is not going to help you. A lot of people script and it's particularly fatal in mooting. And the reason for that is, if your moot goes well, you'll get a lot of questions from the judge, and you'll be chatting to the judge about legal principles and how you understand them and how you apply. You don't want to be looking that down at your script and trying to figure out where you were in your submissions. So you should try and practice them, dot point them, do whatever you need to do. Everyone has a different method for scripting all of their submissions, but I would advise against scripting them because it is obvious if you have scripted, and it will take away from your interactions with the judge. Yeah, time your submissions if you can, and remember to leave 5 minutes as a minimum for questioning. You don't want to have 15 minutes of submissions or you won't get through your material. Think about the way your submissions and your arguments more generally fit together so you don't get lost, and have some familiarity with your teammates' submissions. So you don't need to know that much about your co-counsel's submissions, but you do need to know basically what they're arguing about, because sometimes questions might cross over between the two submissions, and so sometimes in answering a question you might want to answer it briefly and then say that will be dealt with in more detail by my learned junior, etc., etc. So try to have some familiarity with them. And actually, I think it's in the mooting handbook, but if you are junior counsel, your senior counsel is your learned leader, and if you're senior counsel, your junior counsel is your learned junior, just as a general formalities thing. Which sounds a bit funny the first few times you do it. All of the formalities are in the mooting handbook if you want to have a look and sort of get conversant with all of it. I think this is the final couple of slides, which I'm sure will fill everyone with enthusiasm. The handbook has quite a detailed, for those of you who've looked at it, section on answering questions and the different sorts of questions and how you should try to respond to them. So I won't talk about it in great depth. Your research will have highlighted the spots where your case is weak, so think about how you'll respond to questions on those weaknesses, basically. Also consider the logical implications of your arguments, and consider which arguments are essential to your case and which you can concede if necessary. So have a think about, if a judge just won't accept a particular submission, how hard are you going to fight back? Because there are some points where you're going to have to fight and you're going to have to say, with respect, Your Honour, we submit the law is X, and continue to disagree. There are some other submissions that don't matter, and you can say, you can move on fairly quickly. So the final things I've talked about, do remember not to panic, particularly in the face of questioning, because mooting is really unlike any other public speaking you will ever have done, in that the judge will interrupt you and will ask you questions, and it can be very intimidating, particularly if the judge asks you a question and the answer is not immediately clear to you. Just don't panic. You will get through it. You will remember the answer. You will come up with an answer, etc. Just try not to freak out when you do get questioned. And the mooting handbook does actually have some sort of strategies for if it all goes wrong in questioning to help you extricate yourself gracefully from the situation. I've already said all of that. Oh, but just briefly, the judges, do go and ask the judges for feedback, etc. They're usually very, very friendly and will welcome you coming up to have a chat to them and talk about what you can do better, and also talk to the competitions team if we can help with anything administratively or procedurally or whatever. Email. The final thing is we have a new discussion board for you. We've set up a competitions discussion board on the LSS website, so it is going to, well, it does contain links to all of the rules, the policies, the handbooks, etc. It has a big section on mooting resources with some tutorial videos and pictures, etc., etc. It also has a big section on frequently asked questions. I will send around an email tonight about registering for the discussions board, because you do have to register. Please register using your name so that I can approve you and I know who you are as I approve you. I suppose if you really want to use some sort of internet hook, or you can email me and just say the person who has signed up as X is actually me and I will approve you, but you could just use your name. Also, if you have questions throughout the semester, please try to ask them on the discussion board. Igor and I will monitor it diligently, we promise, but it just means that if there is something that is confusing someone we can answer it up there and then you can all see it, as opposed to Igor and I individually answering 20 different questions which amount to the same thing. So do check out, register on the discussion board and then ask questions. Unless obviously it's something you don't want to discuss publicly, in which case do email us. Does anyone have any questions? I'm not sure if that's a good thing or a bad thing. I'm going to go with it being a good thing. Are you sure? Yes.
You said before that you don't necessarily need to move on to in the alternative option if the judge is on side with you. How would you know that? Would the judge tell you that yes, they agree with your proposition, or would they just smile at you encouragingly?
It depends on the judge, to be honest. Most of the time, you'll make your submissions in the alternative because they won't indicate that they agree with you vehemently. Sometimes, though, you'll get a judge who you're making a submission and they sort of say, yeah, I accept that. I think you're quite correct. And that indicates that, yeah, your submissions have been accepted. You don't need to make alternative submissions. No other questions? Well, all the best in your first moot. We will be having another session, probably not so much a seminar, the week after your first moot, because I thought it would be good for everyone to have an opportunity to debrief and ask any questions which arise from the first moot. Were those looks of fear or?
A little bit, yeah, but it's okay.
Okay, good. And I might try and not have it in a lecture theatre because I think you've probably gotten enough of me standing out the front with PowerPoints, etc. So I hope that was all useful. Email Igor and I if you have questions. I will post the video and I will also post the PowerPoint slides, really am turning into a lecturer, for you all tonight. Thank you very much for coming. Good to see everyone.